Welcome to Insta Legal. The topic for today's discussion is what is release deed and its procedure. A release deed is basically a deed when a person is surrendering or giving up its right and title or releasing its right or title in favor of another person out of free will and wish. The document which is executed to do the same is called as release deed. Now it is usually made when a property is inherited by two persons and one of them doesn't want to claim the share devolved upon him. A release deed is different from a relinquishment deed, wherein the person making the relinquishment deed is transferring its legal right to another legal heir with their consent. In common parlance, release deed and relinquishment deed are synonymous terms, but there is a difference because a relinquishment deed is a deed wherein the transfer can take place only with the consent of the another person. However, in release deed, the consent of the another person is not of much importance. Now let us understand why the release deed is made and why it is important to get it registered. A registration of a release deed is compulsory as per Registration Act, and the release deed must carry requisite stamp duty as prescribed by the state where the property is situated. A release deed is basically made only when the party who is owning the property does not want to keep a share and wants to transfer the rights and title of that particular property to another co-owner or another sharer in the property or another legal heir of the property. For example, the person who has died intestate without making any will has two children. Then both the children will get the property in equal after the demise of the person. Now one of the children doesn't want to keep a share in the property and want to relinquish its right or release its right in favor of the another person. In that case, a release deed is basically made. Now the executor would be the person who is making the release deed and the beneficiary is the person who gets the benefit of the release deed. So the executor and the beneficiary both have to be together present before the registrar's office with two witnesses for registration of the release deed. It is important to understand that only a registered release deed is considered to be a valid and admissible document which acknowledges the transfer of the right of immovable property to the other person. Without a registration, such a release deed is considered to be invalid and the person who wants to challenge such a release deed will not be able to do it before any court of law. Thank you very much.